All right, I see none. Mr. Cutting.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to today's session of the Massachusetts Appeals Court. It is January 20th, 2022. The first case on our docket this morning is 2021 P0399, Daniel Wilson and another versus Teresa Brooks Benoit and others. Mr. Hurl, when you're ready, you may proceed.
Morning, Your Honors. Samuel Hurl for the appellant, Daniel Wilson. To please the court, I know there are many issues on appeal and there's a limited amount of time. So I'd like to use this opportunity to address any specific questions you have. Otherwise, I'm prepared to talk about the brief.
Why don't you start with what you think is your best argument?
Sure. So I think as a sort of a threshold issue to the other issues, I think we should address the summary judgment. Now, the lower court granted summary judgment on multiple claims, which included a breach of contract claim against the SMI appellees, Milton Cat, a breach of contract, or two breach of contract claims against SMI, a 293A claims, and all of the intentional infliction of emotional distress claims. We believe that this grant was improper, as there are a significant number of material facts in dispute.
What is the claim? What is the breach of contract that you want to fix on for purposes of your claim? Breach.
So there's two separate breaches. The one breach alleged was for the SMI appellees attempting to seek recoupment of workers' compensation money that they were paid, and the second.
What evidence was in the record on summary judgment that the SMI defendants had sought recoupment?
Sure, Your Honor. So if you look at in the brief, there was a section of Camille Kantorsky, who is one of the defendants and who represented SMI in her deposition. She stated that after the hearing, she reported back to, and this is in the record appendix, volume 2, the sites in the brief. I can provide the pages now if you'd like. Otherwise, sort of in essence, she stated that after the hearing, she went back to SMI and her superior told her to consult with attorney Nason, who was a sort of a lawyer that they had consulted with on workers' compensation issues, and in order to seek recoupment, how they could get their money back.
That's what the record says?
If you look at her deposition, yes.
So she testified at deposition that they asked her to figure out how to seek recoupment?
How to get their money back, yes. How to get the overpayment that had been made. And it's in record appendix volume 2.
What is the act? What is the act that you say is a breach in seeking to recoupment? It is notifying the IFB?
I understand. Yeah, that's where it can get a little complicated because yes, the act was notifying the IFB, which is itself a breach of the other term, the other term of the contract.
Let me stop you there, Mr. Hurl. Isn't focusing now just on your alleged recoupment breach? Does simply reporting the matter to the IFB equate with an effort to recoup payment?
Well, it's if you look at the summary judgment record and the deposition of Camille Kantorsky, it's our position that SMI was advised by attorney Nason that the only way to get recoupment at this circumstance was to report Mr. Wilson to the IFB. And consequently, after they reported him, there was a restitution hearing, and Judge Billings denied them restitution for various reasons.
Let me ask a question on that point. Even if we assume that what you just described was an effort to seek recoupment, and attorney Nason explained that the only way to do that was through a restitution order in the criminal case, isn't the fact that there was no restitution ordered by Judge Billings evidence of the fact that there were no damages on this recoupment claim?
The fact that so what I think is important is that it's disputed. So I guess the point is, since there were no restitution, but they still reported him to the IFB.
Right, but you would still have to prove damages as part of that claim, and I don't know that the record shows that there are any.
So regarding his damages for that particular breach, I mean, the claim was assessed at the claim was assessed for 180, I think, up to Judge Billings described in his.
Wait, you've just jumped topics. What claim was assessed at 180? You mean the future?
The workers' compensation claim.
The future income stream that was lump sum. But that has nothing to do with recoupment. Recoupment is a claim that they had obligated themselves not to seek recoupment, and that they did seek recoupment. And the damage for that has to be actually obtaining recoupment, doesn't it? How is the damage something else?
On that point, Your Honor, I mean, that term was part of a global settlement agreement. It's one of their breaches.
But if they weren't harmed by the particular breach, I mean, the damages have to be causally related to the breach, don't they?
I mean, the recoupment was just one thing that they gave up. I mean, they breached the fact that they reported him to the IFB itself resulted in the damage. So even if
but that's
that's the second, they're sort of intertwined because the act of one is sort of the breach of the other.
That part I get, that there are two breaches in one act. I get your position is that, but the damages have to be causally related to the breach. I hear you arguing now that because they breached by seeking recoupment, that then allows your client out of the contract entirely so that they can then get other damages associated with what they gave up.
I think with either breach, I think I can see, yeah. So the breach, there are two breach of contract claims. Even if they promised not to report him, they still did. They still breached that. There's still that breach, and that breach caused damage.
Okay, so let's talk about the second breach then for a moment.
Sure.
That's a breach of what everybody agrees was an oral side agreement, right?
It was an oral agreement, whether it was characterized as a side agreement. It's true that it wasn't included in the written portion of the settlement agreement, but it was made at the same time. It's part of the same agreement.
And it also seems like there also agreement among the parties, Mr. Hurl, that was an illegal contract, an illegal agreement.
Yes, Your Honor.
So
which is why
you concede that that's illegal?
Yes.
So you cannot agree not to report somebody for a criminal violation?
That's my understanding, and that's, I think, the parties' understanding.
What is the source of the law that says that that's illegal?
I think the lower court discussed that in their order, in the summary judgment order. This has always been whether or not the exception to the impari delicto argument.
No, impari delicto is a defense. Illegality is a different point. If the clause is actually illegal, then that's a separate basis for unenforceability. Forget impari delicto. It's simply illegal, and under our law, we don't enforce an illegal contract clause. If that's conceded that that's illegal, that's very interesting to me. We don't have to deal with impari delicto.
I don't believe
Attorney
that.
Hurl, your argument is that the illegal agreement caused a breach of contract.
My argument is that there was an agreement to not report Mr. Wilson to the IFB, and that by reporting Mr. Wilson to the IFB, he suffered damages.
Right. But if we agree, and it's undisputed that that is an illegal, unenforceable contract, your position is that they breached the contract by breaching an illegal and unenforceable agreement.
Whether it's enforceable or not, my understanding is relates to the impari delicto exception.
So if it's legal, What's your position? How do you have a claim
Uh,
to enforce by violating that? They would be violating the law, right?
Well, Your Honor, the claim itself, I mean, we've always briefed it on the impari delicto. That was the discussion in the lower court, and that's what summary judgment was granted on. That's what the lower court considered. There was analysis of the impari delicto argument.
That's true, but I'm making a slightly different point, which is actually they've got two grounds, and they actually put it in their brief as well, which is that there's a basic rule of contract. You don't enforce an illegal clause. It's unenforceable. So if the clause is in fact illegal, it's not enforceable. I mean, you can tell me if I'm wrong, but they cite some cases, and it was kind of what I learned in law school too.
I don't recall that. I don't recall that being in the brief, Your Honor.
Okay. I was looking for it, so I thought I saw it.
Let's assume, Mr. Hurl, that we reach the merits of the application of the imperi delicto doctrine. If we adopt your position, aren't we essentially rewarding Mr. Wilson for conduct that, well, his criminal conduct, which began this whole case?
Well, the whole point of the impari delicto doctrine is that when two parties are engaged in wrongful conduct, the more wrongful party, if two parties are engaged in wrongful conduct related to the contract, the less culpable party can be entitled to recover. And our argument is that the lower court failed to recognize that there are disputes of material fact related to the conduct which resulted in the illegal term. They failed to consider anything, and the lower court weighed Mr. Wilson's fraudulent conduct against SMI's failure to rewind the contract without including any of the other alleged conduct that the appellant or the plaintiff had made.
So what's the fraudulent conduct of SMI, or I'm not sure whether it's SMI or Sentry, frankly, that you're alleging? One is that
it's SMI or Milton Cat, Your Honor. So there are several, and these are the disputed facts. So the first of which is a $5,000 payment, which was made to Mr. Wilson's workers' compensation attorney. We're disputing, it's disputed whether SMI, you can see in the summary judgment.
Can we just stay on the $5,000 payment for a moment?
Sure.
So as I understand that argument, it is Mr. Wilson, your client, his lawyer was paid $5,000 as part of this agreement, unbeknownst to Mr. Wilson?
It wasn't part of this agreement. If you look at the settlement agreement, it states attorney's fees $0, and it states expenses waived.
All right, as part of this transaction that took place, where
Correct.
your client signed off, his lawyer got a $5,000 check.
Yes.
Right? And that's undisputed, right?
That his lawyer got a $5,000 payment. Yes, that's undisputed.
Okay, and just so I just want to make sure I understand. So, and the evidence in the record is Wilson did not know about that.
Wilson did not know about the payment. It's also in the record, the attorney stated there was no basis. This was a Section 36 settlement. So there was they shouldn't have received a fee, shouldn't have received a hearing fee in the first place.
So why are the defendants before us responsible for that?
Because if you look at Kantorski's deposition, she suggested in part of it that's effectuating that was her idea, was SMI's idea.
To pay the lawyer $5,000.
Yes, and this is in dispute against Attorney Bradley's October 9th letter.
But is it illegal for them to pay the lawyer $5,000?
Whether or not it's illegal is different than whether or not it's wrongful conduct.
Well, what is wrongful about it?
Well,
by the defendants? Spin that out for me. I am on board with you that if the lawyer took a check for $5,000 and did not advise her client, that's a problem. For the lawyer,
it's a commercial bribe.
for the lawyer, that's a problem. Using the words commercial bribe don't get me there unless I understand more about what they did that
Well,
you're saying is wrong.
If it was SMI's idea to effectuate the $5,000 payment, that there was no obligation.
There's nothing illegal with saying as part of a settlement, I'm going to give money to X or Y. That's not illegal. The illegality has to arise from some non-disclosure, some deliberate, what evidence is there in the record of that?
For SMI to say, let's what plaintiffs are alleging, bribe his attorney $5,000 to take away their motivation for going forward with the hearing, that seems like it should be something that's given weight in the impari delicto consideration.
Is there evidence what is the evidence in the record that you rely on that SMI knew that the lawyer was not going to tell Mr. Wilson about the payment?
That they knew that they weren't going to tell. Well, they reviewed the settlement agreement. SMI reviewed the settlement agreement as part of that. They would see that the settlement agreement said attorney's fees $0 and hearing fee $0.
Which means it was not disclosed to the judge.
Well, it's my understanding there was a separate form, but I didn't see that in the summary judgment record. And Mr. Wilson testified that he signed that he didn't know it was there.
Oh, I'm sorry. What was that? There's a separate form that does disclose the $5,000?
It's signed. It's not in the summary judgment record. I haven't seen the form, but it was signed in blank according to Mr. Wilson's testimony.
Mr. Hurl, I see your time is up. Let me check and see if there are further questions. Seeing none, counsel for the defendants, which of you would prefer to go first?
Your Honor, I will go first on behalf of Milton Cat and Ms. Kantorski.
Very well, you may proceed when you're ready.
Thank you. I guess I'll start by addressing some of the issues raised by Attorney Hurl on the summary judgment issue. The first being this recoupment issue. It's clear in the record, if you look at Appendix Volume 2, page 474, this was discussed in great detail in that hearing before Judge Connolly back in the summer of 2019. And Attorney Hurl's colleague, Mr. Caruso, acknowledged that Milton Cat never sought recoupment of this workers' compensation payment. So from the perspective of Milton Cat and Ms. Kantorski, this is a complete non-issue in this matter. Milton Cat never sought recoupment of that money, and that's been conceded by counsel for Mr. Wilson.
Wait. Didn't they try to get recoupment? Didn't they try to get restitution? Wasn't there a hearing on restitution before Judge Billings? What was that all about?
As I understand it, that was just a part of the criminal sentencing of Mr. Wilson. I wasn't involved in that aspect of the case, but the order issued by there was an order issued by Judge Billings.
Tried the case. Judge Billings was imposing sentence in that case. Is that it?
Correct. And then he also ruled on, I guess, on the Commonwealth's motion, I'm assuming whether or not Mr. Wilson, as part of the criminal conviction, was required to pay back the Commonwealth or pay back Milton Cat for the workers' comp fraud. And that was
any
that was the
evidence in the
context of that
record
ruling.
as to whether restitution was requested by Milton Cat in connection with the sentencing?
There's none. There's no evidence that Milton Cat ever requested restitution or recoupment of the monies paid to Mr. Wilson.
So do I understand then, Mr. Suslek, that the only link between recoupment and your client's actions would be the reporting of the matter to the IFB?
That's correct. Milton Cat never actively sought it out. They reported Ms. Kantorski reported the fraud to the IFB at the recommendation of Attorney Nason, who advised her that failing to do so would violate Massachusetts law relating to knowledge of fraud in the insurance context. And it was Mr. Nason's opinion that was a violation of, and I apologize, I had the statute open, of General Laws, chapter, one moment. I apologize, Your Honor. So I had this open and it flipped shut on me.
I hate it when that happens.
tough doing this at home and having. About General Laws, Chapter 266, Section 111A, which states that any person who presents, aids, or abets in the knowing presentation of false or fraudulent statements or representations of any fact or thing material to an insurance claim, and then it goes on, shall be punished by imprisonment. It's a felony. So it was Attorney Nason's advice to Ms. Kantorsky that failing to report this insurance fraud and entering into this side deal to not report the insurance fraud could subject her to criminal liability under General Laws, Chapter 266, Section
Mr.
111A.
Suspect, do you understand that section? That section would criminalize a decision not to report?
As I read it, Your Honor, any person who presents, aids, or abets in the knowing presentation of false or fraudulent statements. So if they're.
But how are they abetting the knowing presentation of false statements? The false statements have already been made. Simply choosing not to report, that's, I gotta tell you, that's a flip over on the law that I'm aware of. Because this is not an uncommon issue. I mean, I've sat around a lot of boardrooms before I came on this bench where people were saying, you know, something was done here that we think is wrong. And a decision is made not to make a referral. And you're suggesting that that decision is criminal.
I would say the decision, insofar as there was representations made to the court on behalf of Milton Cat that the workers' compensation claim was above board and there were no issues when they were aware of potential fraudulent conduct on the part of Mr.
Is there any other
Wilson.
statute that suggests that you have an affirmative duty to report fraud if you're in the position of either Sentry or SMI? I mean, there may well be. I don't see it in the briefs, and that's what I was actually asking your colleague about.
That statute's the only one at the moment that I'm aware of, Your Honor.
I don't know, Judge Kinder, are you?
Go ahead.
Can we jump over to the $5,000 payment? Would you agree that if your client had suggested that a payment of $5,000 be made to the lawyer and that the lawyer not tell her client about it, that would be a problem?
If it would be a problem for the lawyer?
It would be a problem for your client as well, wouldn't it?
If they were told to make the settlement and to take them up to fee and not inform and
not tell Mr. Wilson.
I suppose that could present an issue, but I'm not aware of anything on the record that suggests that Milton Cat affirmatively told Attorney Benoit to disclose that.
What about the fact that we have this document submitted to the court that says attorney's fees $0? Isn't that, can't we draw an inference that somebody was hiding the fact that the lawyer got paid $5,000?
That was not a form that was prepared by Milton Cat. That's an issue that needs to be addressed by the attorney for Milton Cat, who's a separate party in this case, and by Ms. Benoit, who previously was a party in this case. And Your Honors had mentioned, isn't this an issue that should be taken up with the attorney? And it was. Attorney Benoit was sued in this case and eventually.
Who was the attorney
out.
for Milton Cat? Mr. Bradley?
Mr. Bradley was the attorney for Sentry,
okay,
the comp carrier, and he's represented by Attorney Apjohn.
Okay.
So that's that point of it. And
So
I guess
but your response to my question is, I really am not going to answer that because we didn't sign that agreement.
Correct. I think that the agreement was signed by counsel. It's not an agreement that was prepared or signed by Milton Cat itself. That's who I represent in this case.
Okay.
And just very briefly, because my time is almost up on the 93A point, I believe that the dismissal of those claims was proper. This dispute with Mr. Wilson, while it arose after he had been terminated, unquestionably arises out of the employment relationship. This is not a consumer transaction between Mr. Wilson and Milton Cat, which is what 93A is intended to control. I think the case law cited by Attorney Hurl and Attorney Caruso is not correct on that point. The case law that we cite shows that the timing really doesn't matter. It's whether the dispute arises out of the employment relationship. And here, this is a workers' compensation claim that inextricably is involved with his employment with Milton Cat. So it's our position that 93A was not appropriate for this case, and it was properly dismissed by the court.
All right, thank you. I see your time is up, Attorney Suslak, and I see no additional questions. Attorney Apjon, sorry.
Good morning, Your Honors. May it please the court, Eric Apjon on behalf of Century Insurance and Mutual Company, Jody Driscoll, Thomas Bradley, and his law firm Mullen and McGorty. Your Honors, I think in reviewing the argument in this appeal, it's important to remember one simple background fact of this case. The plaintiff is a convicted felon who intentionally and voluntarily defrauded the Commonwealth's workers' compensation system by simultaneously working, collecting workers' compensation, and failing to report his income. The entire underlying case has been his attempt to shift the blame to other people, and thankfully that failed. The Superior Court, through Judge Conley's order in September of 2019, correctly held that the defendants were entitled to summary judgment. The appeal, and to a lesser extent, the argument raised today, because we focused primarily on the breach of contract claim, it's really just a second attempt to relitigate the issues that were raised before the Superior Court at the Rule 56 level. There's nothing.
Well, Mr. Apjon, at least a couple of other judges in the person of Judge Billings and Judge Cipher in her appellate decision at least had some concern about the conduct of your client at the settlement conference.
Your Honor, I believe that Judge Billings actually prefaces his decision by saying that essentially Attorney Bradley and Mullen McGorty were not parties to the civil action. They did not testify there. There was no real opportunity for cross-examination of them. So while there may have been some concern as to how things actually were portrayed by the plaintiff, there was no opportunity to actually take into account the cross-examination.
But it's undisputed that they had an agreement not to refer. That's number one. And apparently everybody believes that that was illegal. And number two, it can't be disputed that that document that your clients did sign and that was submitted to the court as part of getting them to sign off on the settlement didn't disclose the attorney's fee payment. Now, I mean, those are undisputed, right? That has nothing to do with whether anybody was deposed or not.
I think it is disputed as to whether there was an agreement between Attorney Bradley and Century Insurance to report Mr. Wilson to the IFB. They never made such a representation. Their claim was that they would not seek recoupment of payments that had actually been made during the pendency of that comp claim. Their intent was to go through a lump sum settlement, walk away from the case, and they had.
So it was undisputed then that Milton Cat made that agreement.
Correct. Camille Kantorsky on behalf of Milton Cat, but it is not something that Century Insurance had an interest in or otherwise agreed to.
But it is undisputed. There's no disclosure of that attorney's fee in the document that was sent to the court in connection with the settlement, right?
Your Honor, I'd have to go back and look at that. I don't remember that being part of the actual appellate brief, and I agree with one of the statements made earlier this morning that if that was the case, that would really be an issue for Attorney Teresa Brooks Benoit, Mr. Wilson's attorney, who otherwise already settled out of the case.
I don't understand that, counsel.
The
Clearly an issue for her, but somebody who wrote the check, you guys, right?
Century, but Your Honor.
Okay, so Century wrote the check, and then there's a document, which I looked at yesterday, and I'm struggling to find, of course, right now. There's a document that was submitted to the court that says attorney's fees, $0. And I believe, because I looked at it yesterday, that that's signed by Century, right?
I would need an opportunity to double check that, Your Honor. It really has not been an issue in either the summary judgment or the appellate brief to date.
I would disagree with you because I wouldn't have come up with it without it being in the brief, counsel.
Your Honor, what is undisputed, though, is that based on Teresa Brooks Benoit's testimony, Thomas Bradley never had direct correspondence with Mr. Wilson. There would be no way for Attorney Bradley to make a misrepresentation of that attorney's fees to Mr. Wilson. Any allegation that representation was improper is between Mr. Wilson and his separate counsel.
Well, if you create a document that you submit to the court It says $0 on it. I mean, there's no inference available that that was going to be shown to Mr. Wilson?
Your Honor, I can't speak to the representation made between Mr. Wilson and his own private counsel.
I agree with that.
What is undisputed is that Attorney Bradley had no direct correspondence or communications with Mr. Wilson. So as it pertains to the emotional distress claim or the Chapter 93A claim, is really entirely irrelevant to those two claims against Attorney Bradley, Century Insurance, and Jody Driscoll. The payment.
What is in the record? Do you know what's in the record about who it is who prepared the document that was submitted to the court?
My belief would be Attorney Brooks Benoit, but I can't say for certain, Your Honor.
Do you know what's in the record about whether there was a hearing before the judge with respect to that subject?
I do recall that there was a hearing, that the settlement was explained in front of the judge. The judge asked Mr. Wilson if he agreed to the terms, and Mr. Wilson did.
Is that in the record? The hearing transcript in the record?
No, Your Honor, I don't believe the hearing transcript is. I believe it's based on Mr. Wilson's testimony.
John, can I take you off point for just a moment
Oh,
on an
absolutely.
issue that hasn't been raised by anyone yet? There was reference in the pleadings, the briefs, to the fact that Judge Wall didn't act on a motion to compel discovery for some 3 years, and I'm just trying to figure out logistically how that can happen.
I do not know what happened over at the Middlesex Superior Court to allow for that, Your Honor. I do know one of the issues raised when it was brought back before the court is that plaintiff's counsel essentially left it out there to dry. It was submitted, it was filed. No action was then undertaken to ever really follow up on it. What brought the actual issue before the court again was Attorney Brooks Benoit, who had settled out of this case, filed a motion to dismiss for failure to prosecute. It's then when the parties were back in front of Judge Wall that he realized that the motion was still outstanding, and that I think at the time that this was the third oldest case in the session. And he forced the parties to actually sit down, create a new discovery schedule, which the court then adopted. And even within that next period, the plaintiff still did not complete discovery. They had additional time, failed to do so.
So what you're saying is that the record will not reflect any effort by the plaintiff to have that marked up for hearing at any time in that 3 years?
I do not believe a further attempt to mark it up for a hearing was made after it was submitted. I can't speak to whether plaintiff's counsel called the court clerk or not, but I do believe that it caught Judge Wall's attention based on the former co-defendant's motion to dismiss being filed.
All right, thank you. Let me see if there are further questions. Seeing none, I want to thank you all for your argument. The case presents many issues, and we will wrestle with those, take it under advisement. The case is now submitted. Thank you.
Thank you.
Thank you, Your Honors.
Thank you.
Not yet, okay.
The case is now being recorded.
Good morning and welcome to today's session of the Massachusetts Appeals Court. It is January 20th, 2022. Our next case on this morning's docket is 21P0507, Thomas F. Welch and Associates, Inc. versus P3 Partners and others. Counsel, when you're ready, you may proceed.
Good morning, Your Honors. May it please the court, Harry Daniels for plaintiffs Welch and Tours, whose principals are Thomas Welch and Dennis Tours. Beginning in 2000, Welch and Tours led the effort of National Center of Afro-American Artists to obtain BRA designation to develop parcel P3 in Roxbury. Included in that was their establishment of Elma Lewis Partners to be the designee. In 2007, the BRA designated ELP was a tentative gave a tentative designation to redevelop parcel P3. Welch and Tours agreed with the National Center and ELP to defer compensation for their services because the National Center did not have resources to pay for their services. Welch and Tours and the National Center / ELP understood that they would have to involve a developer with the economic clout and financial wherewithal needed to complete the project. In early 2010, Barry Feldman, the president of Felco Development, approached Welch and promoted Felco Development as an experienced developer with the financial means and expertise to bring the project to fruition. Welch and Tours filed this suit in February 2020, I think on February 26, 2020, as a result of events that occurred between 2010 and 2019. Thomas Welch is 75 or was 75 when suit was filed. Dennis Tours was 79. On October 8, 2020, Judge Davis of the trial court granted defendants motions to dismiss counts 1, 2, and 5 of the complaint. On March 2, 2021, Judge Salinger granted summary judgment for defendant P3 on counts 3 and 4. Judgment entered on March 12, 2021, and plaintiffs filed their appeal on March 18, 2021.
Mr. Daniels, can I stop you with a question?
Yes, Your Honor.
From what source of funds did the plaintiffs expect to be paid if the construction loan never came to fruition?
The plaintiffs expected to be paid by the defendants if there was never a construction loan. And the reason for that, Your Honor, is because they negotiated, and it's in the agreement, they negotiated that they would be paid when construction funding was obtained, or in any event on May 1, 2014.
But Mr. Daniels, the fundamental issue there is that the contract is not with, quote, the defendants, unquote. The contract is with P3. What statement is in the complaint alleged that the defendants, that Feldman or Feldco or Feldco Boston, that they made that you believe is the basis for liability here?
The statement was Mr. Feldman's telling the plaintiffs, in response to the plaintiffs telling him that they had to be paid, Mr. Feldman's telling them they would be paid unconditionally, and they would be paid by a date certain. And those statements are memorialized in the contract. And our position, Your Honor, is that was negotiated. If this were the typical deal where everybody understands you only get paid when and if there's project financing, then the agreement that the parties negotiated and Mr. Feldman signed would have been a period after the language that says upon the happening of conditions.
I am with you 100% that reading the contract, P3 obligated itself to make the payment unconditionally. The problem and the interesting question that you're raising is whether somehow the defendants take on an obligation to make that payment where the contract itself, they don't sign it.
The problem—
Is there any law on that, by the way? Because it feels like we're trying to pierce the corporate veil.
Well, I don't think we are trying to pierce the corporate veil, Your Honor, although we have alleged the facts we know, which suggests there may be a basis for piercing the corporate veil. But the basis of our claim is that by representing both orally and in writing that the plaintiffs would be paid unconditionally when that was not true was fraud. It was a misstatement of intention, misstatement of intent, a present misstatement.
Oh, wait, is the word unconditionally used anywhere? Where is the word unconditionally? That's not a word that appears in the contract.
The word
says
that
payment
is
will be made by such and such a date.
that is correct, Your Honor.
Okay, so where is it?
The word unconditionally is not in the contract, but the words that are in the contract you will be paid upon the happening of certain conditions or May 1, 2014, whichever is earlier. May 1, 2014 can't have any meaning if it doesn't mean you get paid unconditionally.
Well, but
Attorney, can I jump in here for a moment, Justice Singler? First of all, Attorney Daniels, all that language is directed to P3. So I agree with you that the language said, if you get the loan, by then. If not, by this date certain, P3, you owe us this amount of money. Would you agree with me, Attorney Daniels, that the contract counts against P3 are still alive and well?
I don't agree. Well, let me put it this way, Your Honor. But for the fact that Judge Davis read paragraph 2 of the contract as established a condition precedent, which we can't satisfy, I would agree with you that the contract claims are still alive. The problem with that is that the contract, we allege, and we think the allegations and the complaint support the allegation that this contract was induced by fraud. And the fraud was a misstatement of the intention of P3, as well as a misstatement of the intention of the other defendants that the plaintiffs would be paid unconditionally on May 1, 2014. Because on May 1, 2014, we allege, I think it's in paragraph 38, that Mr. Feldman admitted in that meeting on May 1, 2014, that he never expected or intended that the plaintiffs would be paid until and unless there was project financing. That's not what the contract says that he signed. And on that basis alone, I mean, that is, this court stated in the Schinkel case that a misstatement of a present intent to do a future act is a basis for denying a motion to dismiss.
I mean, isn't it a risk inherent in every business deal, Attorney Daniels, that if funding doesn't come in, and this is not, a major, this P3 was formed for the sole purpose of creating this whole entity and project. So it wasn't independently funded. And the people that knew that the most were these experienced businessmen that had worked from the very beginning, hard to create something. But isn't it a risk inherent in every business contract that you might end up with no money because the funding stream and the loan doesn't come in?
Well, the answer to that, Your Honor, is as follows. There is a risk. The question is, which party assumed the risk in the contract document? And in this instance, the party that assumed the risk, because there's no claim of impossibility by the defendants here, the party that assumed the risk by entering into the contract was P3, and we submit the other defendants who committed the fraud, Mr. Feldman in particular, and the party.
That's very interesting the way you framed that, because it seems to me it put the finger right on the problem, right? P3 clearly assumed that risk, clearly, because they signed the agreement. But the other defendants didn't assume the risk by the contract because they didn't sign the contract. So if they assumed the risk, it was through some other means.
And the means, Your Honor, by which they assume that
Can
risk.
we
We've
stop
lost
for,
Judge
can
Kinder.
I think we lost Justice Kinder.
we
Yeah.
stop for one moment? Yes, we did lose Justice Kinder.
Sorry to interrupt.
Matt, just kind of keep track of how long this lasts, and then we'll give Mr. Daniels additional time.
Thank you very much, Justice Englander.
In my experience, when this happens, sometimes he can still hear us, but he's not able to get back on. Because I've had experience with this.
The new world.
Well, unfortunately for us, we did this for a year. And the sooner we can stop, the better, as far as I'm concerned.
Agreed.
There is a sense among some that this new world may be here to stay with us for a while.
Well, I do not, you can't include me within the sum, Mr. Daniels.
Nor me. I am too old for that. I still prefer being in the courtroom and being able to feel being in the courtroom. This is foreign to me as well.
We're live streaming it, folks, so we should just be aware of that.
Justice Kinder is aware and he's attempting to sign on again.
It wasn't anything that you said, counsel.
I appreciate that, Your Honor.
I paused the recording.
I'm just happy it wasn't me.
And I certainly am happy it wasn't that, Your Honor.
I'm notorious for being technologically incompetent and therefore glad that it's not me.
I made it a point of doing a practice session with Ms. Ryle to be sure that I would not mess things up. And so far I've succeeded in not messing them up, thankfully.
Judge Kinder may have connectivity issues. Well, we'll see.
All right, Justice Kinder will be here shortly.
Thank you.
Good morning, Justice Kinder.
All right, to have left you temporarily. My apologies, I've changed locations, so I'm hoping we won't run into that again. Matt, let me ask you, have we determined how much time Attorney Daniels has left?
Yes, I
Roughly.
would say five. I'll put the timer at 5 minutes.
All right,
And I paused the
then-
recording, so I have to go live again, and then I'll let you know, and then I will put the timer at 5 minutes.
very good, thank you.
Thank you.
The case is now being recorded.
The response to Justice Walsh's question is I think as follows. It's the defendants say in their briefs that the plaintiffs knew, as Justice Walsh just said. But the other side of that coin, Justice Walsh, is that if the plaintiffs knew that P3 was not going to have funds with which to pay, so did Mr. Feldman know that. And with that knowledge, he still agreed, he still signed an agreement that said P3 would pay on May 1, 2014. And the issue that with respect to the contract language that we're talking about, the complaint alleges facts that we submit show that contract was induced by fraud. And under Bates and Southgate and McCoy and McAvoy and Norton, a contract that's induced by fraud cannot be relied upon the people who committed the fraud to escape the consequences of the fraud.
And the induction by fraud is the statement that they will pay on May 14th, 2010. That statement, you're saying, was fraudulent because he never had the intention to pay?
He never had the
I shouldn't say
intention-
he, because P3 never had the intention to pay?
Well, Mr. P3 never had the intention to pay unless P3 obtained project financing.
But that's not, those are two very different things.
Well,
Saying they never had intention to pay is one thing. Saying that they might have paid if they'd had the money is different, right?
Well, it's only different in this sense, Your Honor. And it's different only in that the contract contains language that says P3 will pay upon the occurrence of those conditions that include project financing. That's what the contract says. But if you say that's what the contract means regardless, then that effectively reads out of the contract the words or May 1, whichever is earlier.
So that's why I ask you, Attorney Daniels, don't you still have a valid breach of contract claim against P3?
I do not, Your Honor. And
Why not?
And the reason I do not is because Judge Davis read paragraph 2 as saying we don't have a right to get paid unless P3 has financing, and it's undisputed that P3 never obtained financing. So he read a notice provision.
We could always disagree with that reading, couldn't we? Couldn't we read the contract as an unequivocal promise by P3 to make a payment on that date? That sure as heck seems what it says, and we construe contracts as a matter of law, right?
Well, that is correct, Your Honor. But the contract also says, even if this court were to read the contract as not containing that condition preceding, to read the contract as providing that the plaintiffs only get paid if and when there's financing, reads out of the contract the words or May 1, 2014, whichever is earlier.
Unless Judge Walsh or Judge Kinder have other questions on this, I'd like to turn to another important question for me. What does the complaint allege that your clients did in reliance on this contract?
In reliance on the representations, my clients agreed to sign, they were induced to sign the contract based on the representations. and the,
And how did that harm them? Signing the contract, how did that harm them?
it harmed.
That's it? That's the sum total of the reliance that you're claiming?
Well, first of all, Your Honor, as I understand the law, reliance is not a requirement of a 93A case. We pled reliance, and what happened here is that my clients relied upon what Mr. Feldman told them orally in negotiating these agreements and in signing the agreements. And in particular, they gave up by signing the October 15 First Amendment. They gave up the mortgage security that was in the September 16 agreement. So that's more of what they did in reliance upon what they were told.
They gave up the mortgage security? I don't understand.
Yeah, in the September 16 agreement, the agreement without the First Amendment, in that September 16 agreement, there was a mortgage security provision. In October 2010, Mr. Feldman went to the plaintiffs and said that mortgage security provision could complicate getting financing. I need you to take it out. And they agreed in the First Amendment that are signed on October 15. They agreed to remove that mortgage security provision, and they therefore had even less leverage. On May 1, 2014, Mr. Feldman said, "I never expected or intended that you would be paid unless there was project financing, notwithstanding what the contract says."
Thank you, Mr. Daniels. Seeing no further questions, Mr. Mack, the floor is yours when you're ready.
Thank you, Your Honor. David Mack for the appellees. Just a quick note, picking up on what Justice Welch said. We conceded by not moving to dismiss the contract claim on behalf of P3 Partners that, of course, he stated a claim. We agree that as of May 2014, and then by amendment, I think it was October 2018, that P3 became obligated to pay. It just didn't have the money to pay. And we disagree that Judge Davis actually held and established as the law of the case that the contract required before P3 became obligated to pay that there be construction financing. He didn't say that. He simply said that what the parties did was they confirmed in writing that the ability, and he uses the word ability, to pay was contingent upon getting financing. Everybody understood that. I want to focus on four overarching themes.
Before you do that, on the point you just raised, I'd like to interject a question. I was curious about your position on the breach of contract claims, which I understood your brief to suggest you were arguing that they should be brought back to life and remanded to the Superior Court. And I couldn't understand how that would be in your client's interests.
Well, here's why, and I've never been in a position of suggesting that a claim should be reinstated, but to be candid, at the time we made that argument, what we were concerned about was just as what's happening here, is that on appeal, we knew they were taking an appeal. We knew that they wanted to get to the appeal because P3 is a defunct entity, and they were trying to bypass the rule that they had to prosecute their case. They couldn't get a separate and final judgment. And we didn't want the opinion of Judge Davis, which we believe is right on point on all fours in every respect, to be tarnished. Now, it's our position that, of course, the contract is plain, that there was an outside date where, for whatever reason, the project couldn't go forward by that date. I mean, it had taken 10 years already. And certainly Mr. Feldman was hoping that he could get it over the finish line. But of course, he said, okay, if there's four years go by and we're still sitting here and we don't have financing, P3 Partners is obligated to pay, of course. That's our position all along. And to all of a sudden turn around and suggest that the contract wasn't as we stated, we felt like the duty of candor has to prevail. P3 Partners doesn't have money.
What is it you think the further proceedings would entail if we were to adopt that position and remand?
It would be a motion presumably for summary judgment by the plaintiffs on the breach of contract claim. We answered the complaint on behalf of P3 Partners. Frankly, I don't think there's going to be any undisputed fact that May 2014 and then 2018 came and went and no payment was made. It's just P3 doesn't have the money to pay. So we saw it as a way of expediting an appeal and jumping the gun. And the agreement, that's what I would think would be a summary judgment motion or judgment on the pleadings. But, and they don't have to prosecute it, and it might be a waste of time. It's more of an intellectual exercise than anything. But there's no question they stated a claim for breach of contract, and Judge Davis, in his opinion, says, I'm not addressing that. And I don't think the decision can be read, the one statement they say is out of context. So go ahead.
Can we, I want you to just assume this fact because it seems to be being said, but it's not entirely being said. Assume that Feldman, separately from the contract, had a conversation with Mr. Daniels' clients. And he said, look, you're going to get paid. Sign the agreement. That's what this means. You're going to get paid no matter what happens. Could they have a fraud in the inducement case? On the other, assuming all the other facts are the same as they are, including all the language of the contract.
You're going to get paid by whom?
I said it the way I wanted to. You can't change my hypothetical.
Well, Your Honor, I'd say no, because the contract is completely at odds with that, and it wouldn't be a reasonable reliance as a matter of law. Because you can't rely on a statement that is completely at odds with the contract. The contract, and remember, this contract is between very sophisticated parties. In fact, I'm quoting from paragraph 32 of their complaint, which says the agreements were, quote,
to you, there'd be a huge difference between you're going to get paid and I will see that you get paid.
Yeah, if you're saying you're going to get paid, all you're doing is reciting the terms of the contract. And all you're doing, a contract, as we all know, is just a piece of paper saying, I promise to do something. And all the P3 Partners was doing was to promise to pay you by the earlier of construction financing or a date certain. So what happens is you got a right to be paid. But this isn't the first time in the world that you go into a contract and someone can't pay. And that's where Judge Davis hit the nail on the head. This is a risk inherent in any situation. If we could make a 93-day,
it wouldn't be inherent if it was accompanied by a whole lot of false financial statements about their ability to pay. Then it wouldn't be inherent, right?
Well, sure, but that's not what we have. We don't have any. This was
well, but I understand your point, and I think, and I don't think you're straying from the record in making that point. But to some degree, that's the nub of what the plaintiffs would like to say is that that in fact it was the functional equivalent of saying I can pay you.
Well, but that's not, it might be what they're inferring, but again, Judge Davis exposed two major holes in their complaint. One of them, Your Honor, hit on during the discussion with Mr. Daniels, which is there isn't an allegation in the complaint that Mr. Feldman, when he signed on behalf of P3 Partners, and they say it time and time again in their complaint, on behalf of P3, on behalf of P3, on behalf of P3, there's no allegation that when he signed that, he had no intention of P3 ever paying, even if it had the money. So all the case law that stands for what I would say is the rather unremarkable proposition that's been settled law in the Commonwealth for 50 years, that if you enter into a contract without ever intending to pay under any circumstances, sure, you can state a fraud claim or a 93A claim, but that's not their allegation. And Judge Davis pressed Mr. Daniels on that repeatedly, and Mr. Daniels, to his credit, at oral argument, it's in the transcript, said, no, we don't have that allegation. And that's at pages 311 and again at 340 of the record. The other allegation that's missing that is equally critical and again, Mr. Daniels, to his credit, acknowledged that it wasn't in the complaint, is that when Mr. Feldman supposedly said P3 partners will pay, that you will be paid unconditionally, quote unquote, he didn't say in the complaint that it was made on behalf of anyone other than P3 partners. It didn't say by whom. And just because you say in a complaint, Mr. Feldman was the president of Felco Development Corp., was the sole managing member of Felco Boston LLC, doesn't mean every single time that person speaks that he's wearing every single hat in his closet. These plaintiffs know that better than anyone, as 85 years of experience and represented by counsel. So you have to, as Justice England, or you hit the nail on the head when you said this looks like a piercing the veil case, because, and they have allegations in there that you normally see in that, such as, pervasive control, thin capitalization. But you have to look at the specific transaction at issue, which is the development services agreement, and see if there's any allegation in the complaint of fact that says when Mr. Feldman signed that document and when he made any statements that he was speaking on anyone's behalf other than P3 partners. Unjust enrichment is just like piercing the corporate veil in the sense that it's an equitable doctrine. And piercing the veil, unjust enrichment, you're only supposed to do that, employ those doctrines, if there's an injustice or an inequity to remedy.
Okay, so let me stop you there. Let me stop you there. So
Sure.
in paragraph 42 of the complaint, says in the years following execution of the consultant agreements, Welsh and Tourist, when requested, continued to advise and support P3 partners with the development of the project. So one could say that that's an allegation that in reliance on the agreement that was made, that P3 got something more, right?
Well, no, I
They
wouldn't say
wouldn't
it's in
have gotten
reliance,
other-
Your Honor. I wouldn't say that's in reliance because, first of all, it's P3 that got more, so it's the
Well,
contract.
it doesn't say. I was going to take it in small bites. You won't even give me the first small bite, so I'm going to struggle to get to the second one. But why can't that be an allegation that not just P3, but also other defendants obtain some benefit from this, from getting Welsh and Tourist to enter into the agreement?
Well, first of all, Your Honor, I think under the agreement, while they had already earned the fee, and it says it, I believe that they were obligated upon request to provide further services. So it's not in reliance, it's in performance of the contract. And again, it's a contract with P3 partners. And all the language in the agreement, all the circumstances.
There's a clause in the contract that obligates them to provide
I
further.
believe that there is a clause in the contract that says that they will, upon request, provide input and services in support of the project going forward. And in any event,
That sounds like reliance. Leaving aside the question whether there was a misrepresentation, that sounds like reliance. That sounds like, hey, if you agree to pay me $6 million for what I've already done, I'll continue to do work for you.
And P3 partners did agree to pay the money. It just didn't have the money to pay at the end of the day. So
Yeah,
it's just a contract, Your Honor.
That's the question, whether there's a misrepresentation. I'm
Well-
on whether there's reliance.
Well, the problem is that anything, the complaint, if you look at the facts alleged in the complaint, there's nothing that Mr. Feldman said or did in entering into these contracts that in any way, based on their facts and their own complaint, were made on behalf of anyone but P3 partners. All they say is that Mr. Feldman was controlled one entity, controlled another. But if you look at paragraphs 30, excuse me one second, Your Honor. Paragraphs 31, 38, 45, 46 of the complaint, every single time they talk about the contract at issue, they are careful. And Mr. Daniels, to his credit, says Feldman on behalf of P3 partners entered into the contract. Feldman on behalf of P3 partners signed the amendment. Feldman on behalf of P3 partners. So P3 partners is identified in the agreement as, quote, the owner. So whatever services have been provided and whatever services might have been provided, and there's no specificity at all about that as to what they actually did, at most it inured to the benefit of P3 because that's who the services agreement was with. So I don't think you can apply this. It would essentially, what they're trying to do is say, anytime you enter into a contract, if you have the intent in your brain that we're gonna meet this contract, we're gonna pay this if we have the ability to pay. If that's required as an affirmative disclosure, it would really change the way anybody negotiates contracts. What's the need to request a guarantee? What's the need to request collateral if you could come back 4 years later and said, oh, you didn't tell me that you wouldn't pay if you didn't have the money to pay? I mean, that's like requiring every common sense concept to be in a contract. And that I don't think would be a good consequence, but that's what would result if the court were allowed this complaint to stand and bring a 93A. 93A is already overused, but this would dilute it even further. I just don't see how requiring someone to stick to the contract and look to only the party to recover is anything wrong. And to the extent that in 2010, maybe the risk was inherent, but one final point is 2018, the guarantee made it so obvious that the only time you can look to someone else is Mr. Feldman first, not his companies, and only if you get construction financing. One final point, which Judge Davis didn't need to, but this would form an independent basis, is there's no damages. There's no damages caused by the failure to pay. They had already suffered every penny of damage, which they deferred without any contract for 10 years. So you need to have a 93A separate damages, a separate link between the alleged conduct, keeping secret the intention to pay only if they have the ability to pay.
What if they did work? What if they did uncompensated work? Does that count? Is that money or property for 93A purposes?
If there's a connection with the actual misconduct.
I would never have done that work if you hadn't agreed to pay me the $6 million that I already had incurred.
I disagree, or I don't think that, I wouldn't not think
that wouldn't be enough. You
93A.
can't, that's not a 93A claim.
If you still have the intention of paying and has the intention of moving forward and seeking financing, there's no allegation that he did anything to drop the ball.
You keep jumping back to whether there was a misrepresentation, and I've moved past that to just try to get the, you were arguing money or property, and my question was, could the time that they put in response to a misrepresentation qualify as money or property for 93A purposes? I don't know the answer. I'll have to take a look.
Yeah, I don't know the answer on the top of the head, but any statement like that would just again be reiterating what the contract says, which is they're obligated to pay, and there's no allegation that he didn't pursue it.
I see your time is up.
Thank you, Your Honor.
I see no further questions. Mr. Daniels, Mr. Mack, thank you both for your arguments. They've been helpful. We'll take it under advisement. The case